Hey, what's up guys? Hope you're having a great day. Today, I thought we could dive into some examples of when legal action was taken due to a print-on-demand design infringing on somebody's intellectual property. Specifically, we're going to look at Ohio State because they got a very active legal team working for them that is not shy about defending their intellectual property, not just the, Ohio State and the logo, but they actually went and trademarked a picture of like fans in the crowd at their games spelling out Ohio with their arms. And this design specifically has been uploaded to multiple print-on-demand marketplaces that we're familiar with, namely Teespring, but I'm also going to show you an example with Redbubble. And it's gotten those marketplaces into some trouble. So let's read some articles that kind of sum up what happened and see what we can take away from how this works, like from a legal perspective. Who should, well, I don't want to say who should really be worried because, yeah, our aim is never to infringe, but should somebody infringe with their designs, like what can we expect to happen as the legal recourse? So let's get started. Quick reminder, please enter the weekly print-on-demand giveaway. It's completely free. And on Sunday, 2 winners are going to be announced. They are going to receive a license to Merch Titans print-on-demand upload automation, Merch Ninja print-on-demand research tools, All Sunsets premium Premade graphics to help you with your designs, and Bubble Scout, the only Redbubble niche research and validation tool. You'll find a link in the description to enter the giveaway, and it's completely free. Also, while you're down there in the description, you can find a link to my 8-day print-on-demand mini course and my print-on-demand Facebook group, which is a great community of people helping each other succeed with print-on-demand. All right, let's go check out this lawsuit. So this is the Columbus Dispatch. It says Ohio State sues over t-shirt of fans forming OHIO. In its lawsuit, Ohio State alleges that Teespring's sale of this t-shirt is illegal because the school has trademarked the OHIO image. It's one of several examples of an entity holding rights to something besides its name. Ohio State won a similar case a few months ago. So this is from 2014, by the way. It's not recent, and I actually couldn't even find out what the actual resolution to this case was. I did some research, and page 1 of Google did not lead me where I needed to go to figure it out. So I'll tell you that up front. But let's look at how much Ohio State was looking for in alleged damages, because this is a lot of money. T-shirts featuring the image of Ohio State's fans forming the letters OHIO are spelling trouble for a Rhode Island company that has been slapped with a trademark infringement lawsuit by Ohio State University. OSU had the image trademarked in 2012, but the school is far from alone when it comes to owning trademarks that extend far beyond normal logos. T-shirts featuring the image of Ohio State fans forming the letters OHIO are spelling trouble for Rhode Island company. All right, we read that earlier. Non-traditional trademarks cover a wide range, including things such as motion, sound, color, scent, texture, and shape. Trademark law basically says you can trademark anything that identifies you, said Michael Spink, an intellectual property attorney with Michigan-based law firm Brinks, Gilson, and Leone. He blogs about the issue at his website, funkymarks.wordpress.com. Typically, when we think of source identifiers, we think of names, Spink said, but there's an increasing trend for things that are not words, colors, for instance. Boise State has registered the color blue as it applies to its field turf. That's interesting that they got away with that. But typically with trademarks, you have to also specify the medium for which you're protecting it on, not just the color blue, Ohio State's suit says that Teespring Inc., a t-shirt company that uses designs submitted by customers, has made shirts with various OSU logos, Buckeye leaves, and images of football coach Urban Meyer, as well as the OHIO image, without permission and without paying licensing fees to the university. Ohio State complained to Teespring in December and again in January, but the company hasn't stopped. Does that sound familiar, guys? Like this is literally like Ohio State University with a real legal team trying to stop infringement, okay? Because I know that like everybody watching this has been ripped off probably at least once and been faced with the decision of like, do I try to fight this? If I try to, how do I even start? Because some of these marketplaces don't even have a mechanism to use, and then Teespring has a mechanism to use, and they just ignored Ohio State University, so it's crazy. Teespring continues to solicit orders for manufacture, sell, and ship infringing and counterfeit products using the Ohio State trademarks, Ohio State said in the suit, which was filed in April of 2014 in the U.S. District Court in Columbus, Ohio. The university wants Teespring to stop its unauthorized use of OSU trademarks and seeks more than $1 million. You got to do the Dr. Evil, $1 million in damages. Ohio State has been aggressive in protecting its brand, said Bill Faust, the chief strategy officer of Orbitkit, a Columbus marketing company that has universities among its clients. A few months ago, for example, the university won a similar lawsuit against Columbus-based t-shirt company Screened. I wonder if they're still around. Screened t-shirt. Screened, there's a Facebook page, there's a Twitter page. I don't see a website, though, which means they may have had to close down as a result of potentially... Actually, I don't know. Maybe they weren't that big, too. It's possible they were just a small Ohio gig. But it's possible that also losing to Ohio State University, they had to close down. OSU is still negotiating with Screened over the dollar amount of damages. U.S. District Court Judge Gregory Frost has set a mediation hearing for damages in August. When it comes to protecting trademarks in higher education, the big public universities tend to be more aggressive than anybody else and tend to be more aggressive on the athletic or spirit side, Faust said. They're protecting the revenue stream. There's so much money in licensing sports, icons, and mascots. Teespring did not return requests for comment. However, in filing late last month, seeking to have the case dismissed, Teespring argued that the company did not create any shirt designs that OSU alleges infringe its rights, and that it has, quote, rejected and removed hundreds of potentially infringing campaigns at the request of intellectual property owners, including Ohio State. Which is interesting they said that because, remember, if we just scroll back up, Ohio State reached out in December and January, and it wasn't effective. Like it didn't get whatever they had reached out about removed. They said that. Ohio State officials declined to discuss the case since it is still pending. However, university spokesman Gary Lewis said that Ohio State is very pleased with the Screen decision, of course, because they won. He noted that the court went even further and found that this was an exceptional case and ordered the t-shirt company to pay Ohio State's legal fees and damages, a type of award that is a forceful message and would be infringers of our marks. A variety of schools and companies have taken steps to protect the logos and sounds and chants that they view as uniquely theirs. So then it says that University of Arkansas filed to trademark a sound, which is absurd. And if we just kind of go through here towards the end, Ohio State's filing for a trademark of OHIO image was a good move, the lawyer said, of course, because they're winning lawsuits now protecting it. Ohio State registered that image for all kinds of things. Apparel, by the way, apparel, take note, that means no t-shirts, blankets, things like that. They say that when people see those letters being spelled out, they recognize it's coming from the university. Here it seems that consumers seeing the apparel might believe that the item was endorsed or sponsored by the university. So yeah, guys, I couldn't figure out the resolution between them and Teespring, honestly. I know that's kind of anticlimactic, but I searched. I just couldn't find anything. I did find this on casetext.com, which is not a website I'm familiar with, but maybe if you've been to law school, you might recognize it. And at the end, after kind of scanning through it and being like, man, I can't read this. This is too much. I can't do the lawyer jargon. All right, section 3, conclusion. And it's not like a good conclusion that tells me what the outcome was, but it says, as noted by Judge Frost in Screened, selling knockoffs is selling knockoffs, regardless of who suggested you sell them, regardless of how many other infringing products you decide not to sell, and regardless of how much of a hassle it is to comply with the law. Teespring is no different. So it's sounding like Teespring probably lost the case. I don't know. I doubt they had to pay $1 million in damages if they did actually lose. But also, again, I couldn't find for sure if they lost or not. But yeah, so this is why websites like Amazon and Amazon Merch try so hard to algorithmically police the submissions at scale, which is no easy feat, right? But that's the concept, is they're doing it at scale because the alternative is you have to do it manually. And if you do it manually, you can't review every submission. If you did that, you'd kill your business. And so then what do? You let people submit, and then you have to actively, manually review when people like Ohio State University come to you and say, hey, can you take this down? It's infringing. But then the person receiving that, you're only human, right? So then do you actually go and try to verify whether or not this is actually infringing or not? If so, you basically need to be a lawyer. I mean, you don't have to be a lawyer, but you kind of do to make sure that you're right. So it's interesting, guys. Let me know your thoughts in the comments below as far as how this should be handled. Should Teespring or Screened have lost the case? Should they have won the case? Because it is kind of interesting. It's a gray area since the print-on-demand sellers submit the designs. The marketplaces are the facilitators of the transaction between, you know, a buyer and the seller. And then they also print and fulfill and ship out the product. So it's interesting, right? And of course, the lawyers, the legal teams for places like Ohio State are more likely to go after the marketplace because they've got more money. At least that's how it works in my mind. But I mean, maybe they couldn't go after the seller. I don't know. When I say the seller, I mean the people that uploaded the infringing image. And real quick, I just wanted to show you one other case. So Ohio State started a trademark infringement suit against Redbubble as well. And the United States District Court for the Southern District of Ohio in April 1st, 2019, not that long ago, 2 years ago, held that Redbubble Inc. was not liable for direct infringement of several Ohio State University trademarks in the Ohio State University versus Redbubble Inc. Ohio State alleged that Redbubble, a global online marketplace which allows independent artists to upload and sell products, sold infringing products on their platform. Redbubble's business model relies on the automated use of third-party services. Artists are automatically connected with a third-party manufacturer to make the goods, a third-party service to package and ship the goods, and a third party to process payment for the goods. That's a good way of putting it. So Redbubble is kind of the middleman for a bunch of different services that ultimately, you know, create the product, ship it out, and also process payments, right? The court found that Redbubble's actions resemble those of an auction house as opposed to companies that themselves manufacture and ship infringing products to a customer, and granted Redbubble's cross motion for summary judgment. That's interesting. So if Teespring owns their own production facilities in-house, then they wouldn't meet that definition, by my understanding. Whereas Redbubble, being a middleman, kind of like Printify, and farming the work out, they were not found to be a manufacturer, right? They're found to be an auction house. This is probably why, like Printful, for instance, anybody that's ever tried to, like, I've never tried to infringe in Printful, but I've sold designs that were like, not necessarily, they weren't infringing at all, but it was more or less like kind of like a funny one that maybe was like a little too edgy. Like one comes to mind because it still sells pretty regularly. It was a t-shirt that I saw somebody wear on the Joe Rogan Experience, basically. Again, nothing wrong with the design, but it's a little bit too edgy, and Printful just doesn't fulfill it. So anytime it sells, I pop on over to Gearbubble, and then they're willing to fulfill it. So anyways, but also before I wrap the video, guys, did just want to mention that right here in this article from law360.com, it says that the Sixth Circuit on Thursday revived a trademark lawsuit filed by Ohio State University against a print-on-demand service that allows users to create unauthorized Buckeyes gear, ruling that such sites bear more responsibility than a mere marketplace like Amazon. So they have revived the case. And this was in February of 2021. So Ohio State's lawyers, man, they seem vicious. Do not mess with them. All right. Ohio State University's lawyers. And I don't know what, if this is still going. My guess is that these things tend to get drawn out. So it's probably still going, but they are still fighting Redbubble. Thanks for watching, guys. Before I wrap up, I just wanted to remind you that I wrote a full print-on-demand course walking you through how I make six-figure print-on-demand sales every single year. You can, of course, find a link to it in the description, and you can find way more about that opportunity. Thanks, guys. Please like and subscribe if you haven't already, and I will see you tomorrow with a new video.